If you've been told by a collection agency that they can show you how to collect your money at no cost to you, don't believe the lie. Hi, it's David Weiner, Mr. Cashflow. Stay with me for the truth of the matter. Many businesses have been told by their collection agency that they can provide free collections to them simply by adding the percentage fee onto the debtor's balance as the cost of collections. In other words, they're promising prospective customers something for nothing. With the high cost of collection agencies, that's a very tempting offer, especially for a business who needs to collect their money and hesitates at paying an agency their typical 30 to 50% fee for collecting. Don't believe it. First of all, the math doesn't work anyway. If the fee is 50%, and the agency or the client adds the 50% back into the bill before it's collected, the client will only receive 50% of the new balance, which is not the full amount. Actually, it's only 75% of the original bill. More importantly than that, the agency is tempting you to violate federal laws against usury. The agency is setting themselves and potentially you up for a lawsuit and stiff fines and penalties. Even if you put a statement to that effect into your financial policy, you may not charge these percentages to recoup your collection fees. Send me your email address and I will send you an article by the American Collectors Association about this problem. In a January 2nd, 2014 ruling, the 11th Circuit Court of Appeals found that a collection agency may not collect a fee based on a percentage of the account balance if the original contract between the consumer and the creditor did not specify the consumer would be responsible for a percentage-based fee. In the case Bradley versus Franklin Collection Services, Inc., the consumer plaintiff had signed a patient financial policy when receiving medical care that stated, in the event of a non-payment, I agree to pay all cost of collections, including a reasonable attorney's fee. The creditor subsequently added a 33 1/3% fee, which reflected the contractually agreed upon fee between the creditor and the collection agency to the top of the bill before forwarding the account to the collection agency. The court ruled that the plaintiff had agreed to pay the actual cost of collection. His contractual agreement with the creditor did not require him to pay a collection agency's percentage-based fee where that fee did not correlate to the actual cost of collections. The court found that the percentage-based fee assessed before the collection efforts were attempted was not related to the agency's actual cost of collections, thus breaching the agreement between the consumer and the creditor. Therefore, the court held that the collection agency violated the Fair Debt Collections Practices Act by collecting the 33 1/3% fee when the consumer only agreed to pay the actual cost of collection. Please let me show you a way to avoid paying the percentages charged by these collection agencies without running afoul of the law and while collecting more money than they typically do in the process. Email or call me for more information today. Also, if you'd like, subscribe to my YouTube videos or my blog, Mr. Cashflow's Tips and Tricks at mrcashflowblog.com. Cash flow strategies. After all, it's your money. Keep more of it.